Good evening, everyone. Welcome back. Welcome back. Hey, Alberta. Good evening. Welcome back. Hey. Come on in, you guys. Come on in. We'll give YouTube a chance to let everybody know that we are live and we got something to talk about. So let me get this off of here. Welcome, Alberta. We haven't seen you in a couple of days. So glad that you're here. Let me get my stuff set up here while everybody comes on in. As you come in, hit the like button. Thank you for supporting the channel. It really means a lot. There it is. All right. Hey, everybody, come on in. Come on in. Hey, Harlem. Hey. So we're just allowing YouTube a minute to let people know we are live so we can talk about it. While I get my stuff set up here. No, not that. So over here. Oh. Um, I'm trying to get my stuff together here. Yes, I have them. That's what I'm working on so I can get them pulled up here. Thank you for sending them. I did find them. But why is it doing this? So let's see. Over here. Oh, no. What is that? I think I'm back. Cut myself off. Okay, I'm back. I'm just trying, y'all. Give me just a minute. I'm trying to get the documents up so we can jump right into the conversation. We want to get this done. We want to get this started. We don't want to waste no more time. Okay, so right here. And then I want to file. Okay. Okay. Got that. So here, back here, share. Did I do something? April Showers is here. Welcome back, April. Thank you for being here. Hey, Harlem. Harlem, did I do something? Did I mess something up? Cancel, share. Oh my gosh, it's not. Okay, we got to figure this out again. Oh, I know. I was like, where did I go? But I'm back. I was trying to get the documents up and wasn't working, but we got to get this done. So, all right. So download. Do I want to download them? Yeah. And then I want to go file. And I want to. Jesus, what is it? Oh, okay. Maybe that's it. Do I keep disappearing? Welcome, everybody. So, welcome back tonight. We got a lot to talk about. As we know, Diddy was denied his request to he was denied his request to overturn and have a new trial. The files are giving me heck to get up, but we're gonna get it. Again, every time. Hey, right, you have not missed anything. You are on time. You are on time tonight. It's me trying to get these files up, and we're gonna get it. It's going to work. Some reason it's not right now. How's everybody doing? How was your, what is this, Tuesday? How was your Tuesday? Glad to see y'all. I'm just, every time we have these, I downloaded it. I don't know if it's the way it was sent, but it shouldn't be acting like this. Okay. Justice for Natanya, justice for Tupac and Biggie. Okay, so I have dropped that. All right, I think I got it. So it gives me heck every time. So I dropped the link. Of course, we're talking about all things P. Diddy tonight. That's what we're talking about. We understand that Judge Submarinium has denied his request for overturn. He's not going to drop any charges. He's not going to have a retrial. We said that. We stated that's probably was what going to happen. That was what was going to happen. And it just took him this long to let us know that it was going to be denied. But figured that would be denied and that they would move forward to October the 3rd, which is this Friday, for sentencing. And again, I think I still stand where I stand. What also has come out is that the prosecution has also came out and stated that they're seeking up to 11 years in prison. And so they also had, and we have those letters as well. Shout out to you, Harlem. We have the letters that Cassie, Mia, Deontay, somebody else wrote. We have those letters, but Jane Doe has not written a letter. She has not written an impact statement at all. So we'll go over these briefly. This is a whole long file. I know that you guys, we don't just like to continue to read, but we're going to read some of it and understand why he denied it and what he was denied it for. Capricorn was, and that's right. I'm right. You're dead on. I think you're spot on. He will not walk. He will not get time served, no matter how, no matter how, I mean, he has to keep hope, but no matter how people think that Judge Submarinium is just going to let him walk. There was a lot of stuff that he can't unsee. There's a lot of stuff that was seen that he can't unsee, and that he's going to have to pay for. Some people are saying that what they're doing, what the court is doing, is they're charging him for the RICO charge, which is something that he beat, and that they have to be careful of that because he did not he was not found guilty of that. And so what they're doing is punishing him because he wasn't found guilty on those charges. I don't know what you guys think, but you can start talking about it in the chat. There's a link in the chat that you can hit and you can come up on stage and we can talk about it. But I'm going to read a few of these real quick. And then I'm going to read a couple of the letters so we can understand the impact, because as you guys know, the defense, when they came and they put in what they submitted their character letters for Diddy, it was like 65 letters, and there was just a handful of people, which is very believable, right? Whenever you have just about a handful of people that will write an impact, but you have 65, 70 people saying the same thing and making him look and shed him in a good light, which that's what a defense is supposed to do. They're supposed to fight to the end, and whatever strategy they have, they're supposed to use that strategy. But also that's what the prosecution is here for too. And they use great strategies as well. So at this point, up until today, from the time Diddy was arrested and had been requesting bond three to make bail 3 or 4 times and denied. He every request that he submitted was shot down and denied. Everything has been a denial. And so October the 3rd, I think that it's not going to be time served. I think he has his mind made up on that one as well, that he's going to do some type of time. Puff letters turned out to be about 100 plus letters to try and point him as a religious family man. Exactly. So if he was very religious, as a religious family man, what happened to the time? At what point did you have time to do all of those freak offs that was happening? So, I mean, I think that that's what the judge is looking at. I think that the judge knew he was going to deny it. He just put us on hold. Judge might say something like, I don't think you are reformed. I don't think you've taken steps to better yourself. You're abusive and dangerous. So take this time to get help and become better. Quite possible. Hey, Capricorn Luxury, thank you so much for being back. We are talking about all things P. Diddy. And if you guys want to join in on the conversation, you can definitely do so just by hitting the link that's in the chat. Alberta's here tonight, y'all. Say hello to Alberta. So let's just jump right in because there's kind of a lot to talk about. These glasses are kind of crooked on my face. All right, so let's just jump in. Oops, I got to get out of there before I can do this so I can see it all. So we'll talk a little bit about the background, about what led us to this. We'll skip over this because it's a very large file, and I want to be able to see it so I can read it. Anyone is welcome on the panel. Yes, anyone that wants to come up on the panel, the link is in the chat, you guys. So when we start having the conversation after I read these things and you want to come up, we'd love to have you up. Okay, so let me see here. All right, so United States of America against Sean Combs, the defendant. Arun Subramaniam, United States District Judge. After an 8-week trial, a jury convicted Sean Combs of 2 counts of transporting people for prostitution under the Mann Act. Before the government rested its case, Combs moved for acquittal under Rule 29. The court reserved its decision under Rule 29, and Combs renewed his motion after the verdict. He also moved for a new trial under Rule 33 for the following reasons. Both motions are denied. So just a little background, as I said, the government first indicted Combs in September 2024 for violation of the Mann Act, for ex-trafficking, and for racketeering conspiracy. In its third and final indictment, the government's case was built on Combs' action beginning in 2004 and continued over the next 2 decades. The government alleged that Combs arranged for and paid men to travel across the U.S. and internationally to have sex with Combs' girlfriends, Cassie Ventura and Jane. Further, the government alleged that Combs transported Ventura and Jane to have sex with those men, gave them illegal drugs, and physically abused them. This, the government argued, was all the product of Combs' enterprise, a criminal organization comprised of Combs, his business, and his employees. On the government's telling, the organization existed for lots of reasons, not only to run a global business in the media, entertainment, and lifestyle industries, but also to fulfill the personal desires of Combs, particularly those related to Combs' actual gratifications. The case went to trial. After the government rested, Combs moved for acquittal. That motion focused mostly on the racketeering and the ex-trafficking, but also contested the Mann Act charges. With respect to the Mann Act, Combs argued that the escorts who testified didn't travel across state lines, that they disavowed that they were paid for sex or engaged in prostitution, and that they sometimes were paid even when they didn't have sex. The court withheld its decision, and the charges went to the jury. And this is just just refreshing our mind. The jury agreed with Combs about the ex-trafficking and racketeering charges, acquitting him of both, but it disagreed with Combs about the Mann Act, finding him guilty. Combs now renews his Rule 29 motion and also moves for a new trial under Rule 33. So then they talk about all the legal standards, okay? So we can pass the legal standards, because a lot of that is just saying that the defendant has to prove this the defendant bears the burden of proving what he's asking for and how he's asking to have this stuff dismissed. Like, so that's just all of the legal standards. The discussion is this. Combs makes two types of arguments under Rule 29. Legal ones about correct definition of prostitution and factual ones about the evidence at trial. On Rule 33, he argues that the evidence on the acquitted counts prejudiced the jury on the counts of conviction. So Rule 29 legal arguments are this. The legal arguments in Combs's Rule 29 motion turns on what the word prostitution means. And this was a whole big old deal about what the defense thought prostitution meant and how they said the updated meaning of prostitution, right? And what the prosecution thought it meant. So it says that the argument on Combs Rule 29 motion was all around what prostitution meant. Okay. So then in interstate or foreign commerce, but they have different intent requirements. The first clause, the one at issue here, requires that the defendant intend that the transported person engage in prostitution. The second clause, a broader catch-all, requires that the defendant intend for the transported person to engage in any actual activity for which any person can be charged with a criminal offense. Together they read, whoever knowingly transport an individual in interstate or foreign commerce or in any territory or possession of the United States with intent that such individual engage in prostitution or in any actual activity for which any person can be charged with a criminal offense. So Combs didn't forfeit or waive these challenges. The first question in whether Combs can bring a legal challenge to his conviction on Rule 29 motion. The government contends that Combs should have made his challenge earlier under Rule 12. So that what they're saying here is that he waited too long for his argument. When it was time to argue that, he didn't argue it. He waited too long. So they're like, too late, so sorry, so too bad, so sorry. The government contends that, okay, that he should have argued that earlier. And that the instruction given to the jury on the definition of prostitution was of his own devising. And so he waived any claim of error. So he's saying that what they got is what he agreed to, and he didn't say that there was an error at that time. And then later on, he wanted to come back and say it was an error, but it's way too late to do that. He should have done it at that time. So first, Combs can bring his legal challenges under Rule 29 despite not raising them earlier. These challenges are routinely made and decided by courts in the circuit, including the Second Circuit itself. So second, Combs didn't waive his argument concerning the definition of prostitution by proposing the instruction the court gave. To be sure, this case involves an unusual series of events. Combs proposed the instructions. The court adopted it, and now Combs says that it was wrong the whole time. So what he had been agreeing to this whole entire time, he's now coming back and saying that was the wrong definition. We don't agree all along. It's just been the wrong definition. So now he wants to challenge that. Combs argued that his Rule 29 motion doesn't challenge the jury instructions, but instead turns on what the definition of prostitution should be. On that view, the jury instructions aren't relevant. I can't talk tonight. To his arguments. All right. So what else? So Combs is right. He says that in Masaccio versus the United States, the Supreme Court held that reviewing court's limited determination on sufficiency review does not rest on how the jury was instructed, though that holding addressed only whether the due process clause requires that an appeals court abide by erroneous jury instructions, meaning the wrong instructions. They were given the wrong instructions. Given below that advantaged a defendant. The Second Circuit extended that reasoning shortly afterwards. And then B, Combs' newly proposed definition. So after he did all of that and said that's the wrong definition, it says Combs' newly proposed definition of prostitution is wrong. So Combs was arguing that prostitution, properly defined, has two elements absent from this case. First, the defendant must have a financial motive. Second, the exchange of money for X must be bilateral. Whoever pays for the X must engage in it. So do you guys see what he's saying? So if you go back to the trial, and every time he had a FO, he was not engaging in actual behaviors as a threesome. He never had actual encounters with the males, only with his girlfriends. So this is what he's arguing right now, that the law says, he's saying that the right way is that both arguments, that defendant must have a financial motive, and exchange of money for X must be bilateral, and that whoever pays for the X must also engage in it, and he did not engage in it. So that was his fight. That was his battle. He says the correct definition of prostitution in the Mann Act is X in exchange for money or its equivalent, and that definition poses no constitutional problem. So then they said, to any modern reader, the plain meaning of prostitution is X for sale. Every modern dictionary at the court dictionary the court consulted says the same thing. Every one of them said the same thing. It says the practice or occupation of engaging in actual activity with someone for payment. The act or practice of engaging in X acts, and especially actual intercourse, in exchange for pay. Black's Law Dictionary, all those dictionaries, he says the practice of an instance of engaging in actual activity for money or its equivalent, commercialized X. So they're saying that we went to all of these dictionaries, every type that you have in the court, and they all say the same thing, that what prostitution means is an act of someone paying for actual encounters, for actual engaging in actual encounters. Let's move on. That's all about the Congress. So it says a defendant need not to have financial motive. So what Puffy is saying here is that, so he didn't have a financial motive. He was just being pleasured, and because he's the one with the finances. So how can you say that I had a financial motive in this when I was the one paying for it and I was just being pleasured? So Combs first argues that prostitution in the Mann Act requires that a defendant have a financial motive. There is nothing in the text of the statute to support this requirement, and it doesn't make any sense in this context. Combs wasn't convicted of prostitution, but rather transporting others for prostitution. So you see the meaning right there? That's their argument. Combs seems to be conflating two things. It says that the definition of prostitution and the motive of the defendant who transports somebody for prostitution. The statute requires only that the intent that the transported person engages in prostitution. Combs's argument imposes an additional mental state requirement for the transporter and grafts it onto the word prostitution, a word that by itself doesn't complete anybody but the parties involved in the X Act. What happened in this case was transportation for prostitution. Even under Combs' understanding of the terms, Combs transported the escorts who were financially motivated and intended for them to engage in sexual behaviors. Whether Combs himself was financially motivated never enters the calculus. There is no bias to adopt Combs's proposed financial motive requirement for defendant in the Mann Act. So this is all the judges just responding to Combs is arguing, what Combs is arguing, and he's just shutting them down on every angle of it. Bilateral exchange for money. So I think this is like the really long one. We could read this all day. We could go on all day about what they're arguing, what their argument is. And basically what it comes down to is that this whole document is going back to state why his requests were denied and giving reasons that even though you're saying that this happened, and you never received money or you never took the prostitutions across the line, they never, like all the arguments that he's arguing, the judge is shutting down saying, yes, I understand that, but this is what the law says. And I told you guys, I said, this judge is by the book, by the book. And that's exactly what this is telling us. Let me go through the chat really quick to see what I've been missing and who I've been missing to say hello. So I said hello to Corporate Luxury. Hey, to Alberta, of course, Harlem, to Cash. Hey, y'all. Hey, April Shower said hello again to the chat. I saw Wright said, I saw it coming years ago. I just flew her out. Flew her out for what? Milk and cookies. Both parties knew why she was going. Sharing with two of my friends. The live? Thank you. To Cash. Hey, we just really getting started. Alberta, thank you. Yes. Welcome everybody. It's more than one definition around prostitution. And exactly. Well, but that's what Harlem, I think that is Diddy's entire argument is like, y'all are looking at this way, but we believe it to be this way. And so, but the judge just keeps coming back with, yeah, but, and this is why not. And this is why it's denied. But he paid for any of the activities. Yes, he paid for the activities, but what his argument is, according to what he put in the argument, was that he might have paid for it, but he didn't have any motive to be paid, and he didn't have any motive to engage in the activity, right? So that's what he was trying to fight. But he paid for it, yes, okay. And then he says depends on the statute. Also, it doesn't necessarily have to be money. It could be favors, gift, job position, future benefits. Yeah. Actually, absolutely. Federal government wants Diddy. That's just the bottom line. Correct. It doesn't matter. Okay. So I think I got caught up on all of that. So let me see if I can find anything else that really is relevant to other than what they've already said. Get that off of there. So, right, I'm gonna have to wait. Just a second, y'all. So, right, you're saying it doesn't matter though. So, are you saying that because I think this is where you are, and I just want to make sure. Are you saying that when I talk about him not getting financial gain and not acting in the activities, that it doesn't matter because he paid them and he took them across state lines for the intent to have these freak offs and engage in sexual behaviors? Is that where you are? Is that what you're saying? Because I want to make sure before I move on. Gotcha. So that was his argument. And I'd be interested in saying why you say it doesn't matter when clearly the case that they found stated that. Like it says that it has to benefit this person financially and he has to engage in sexual behavior. So why wouldn't it matter? I guess. I'll wait for your answer before I move on. Again, you guys, thank you so much for being here. Hit the like button. If you haven't already, we do appreciate you. That supports our channel for free. And it also keeps us in the algorithm when you guys were trying to grow the channel and do better. And so we just appreciate it. So I'll come back to you, right, because I really want to understand why doesn't it matter if that's what it stated. Oh, here, you came. So it says because he orchestrated it, he funded it, and the very least, he's an accessory. So, but yeah, but when are we still going to ignore the fact? And I'm just playing devil's advocate, right? Are we still going to ignore the fact that it says that he has to be one that gets financial gain and interacts that engages in the activity, meaning having actual X with those people? So we get to ignore that and just say, yeah, well, he orchestrated it, he funded it, and at the very least he's an accessory. Like, right? Is that fair to him? Or is that just the law? Is that how the law works? It doesn't matter if you did engage. The law states that if you carry someone across state lines for purposes of having actual behaviors with them or actual activity with them, then you're breaking the law, right? Thank you guys. If you have any friends out there that wants to come over, invite them, let them know we are live and we're talking about it all. After this, we're going to talk about the letters that were submitted for the prosecution against him. Yes, he cannot transport or facilitated. Okay, I get it now. And it is the law, right? You cannot say, I'm going to fly you out from here across these state lines, because I think that's where R. Kelly got caught up too. There were several state lines that he crossed to bring people there with him to engage in sexual behaviors. And so that kind of got him hung up too, I believe, if I'm correct. All right, so let's just keep it pushing. Thank you guys for interacting. This is good. I love it when you interact because it keeps me going. It keeps me going, keeps me fired up. All right, let's just move on. Let's see what else we can find in this document that is important, we think is important. Okay. Oh, I didn't see this. Okay, it says second, the lack of a definition isn't a problem. As the government notes, a statutory term is not impermissibly vague simply because it lacks a statutory definition. To be sure, the absence of a statutory definition can be a relevant consideration in the void for vagueness inquiry. Now they're getting over my head. Break it down for me. But the plain meaning of the statute's wording, along with a scienter requirement, can defeat a vagueness challenge. Okay, let me move on. The state law definition that Combs raises. Okay, here's what Diddy is raising. This is another reason why he thought that it should be thrown out. He says the third thing is that the state law definitions that Combs raises aren't relevant. What? Judge is saying the state law definitions that Combs raises are not relevant. Well, why not? Well, though the Mann Act has a provision that integrates state law, that isn't the one that Combs was convicted under. If Combs' argument is that a constellation or conflicting state law renders the federal term vague, this presents two further problems. The first problem is that, as has been already discussed at length, the state law cases that Combs cites don't conflict with the definition the court used. And even if they did, they interpreted status with different language. That's why I get confused, because in some of the stuff, it has different language meaning the same thing. And sometimes it has different language meaning different things. And so that's where I kind of get caught up. And that's why I'm working on this attorney to come on here. I've been saying that, and they tell me yes, and then they don't come, but that's okay. We'll get one. If anybody knows a lawyer that will come on this channel and share with us, please let me know. Anybody in the chat. Share this out with your friends, you guys, and tell them to come on over and join the live. Also hit the like button. So the first is that, as has been already discussed at length, the state law cases, the Combs cites, don't conflict with the definition of a court use. And even if they did, the interpreted statutes with different language. The second is that even if there were a conflict, the court is skeptical that a federal statute could be, defamed by state laws that occupy a similar field. The principles of preemption and intergovernmental immunity run in the other direction. Let me say that again. The principles of preemption and intergovernmental immunity run in the other direction. So they're total opposites, is what it's saying. And then the fourth thing is that it makes no difference that this statute may not have been applied this way before by the government. Combs argues that he's the only person ever convicted under the Mann Act for his conduct. He's stating still that there is no other case law, there is no other person that has been convicted under this Mann Act in this way but him. But I thought that when the judge asked both sides to come with case law, that there was one found on the prosecution side. But he's still arguing the fact there's no other person, it's just him. Combs fails to show that his conviction implicates any right or liberty interest protected by the Fifth Amendment. He argues that laws banning prostitution are hard to square with Supreme Court decisions recognizing substantive due process rights related to sexual activity. So in doing so, he leans on two cases that are in opposite. First, he cites Obergefell versus Hodges, which concerned only that right to marriage, only the right to marriage. What? So he brought a case law that talked about marriage, but not any specific right to participate in sexual activity. So why would you even bring that case law? Because that has nothing to do with nothing if that's what that case law states, and it only has to do with marriage. And then it says, second, he leans more heavily on Lawrence versus Texas, which did concern sexual activity. But as the government points out, the Lawrence court explicitly wrote that it wasn't addressing prostitution. This case does not involve prostitution. So what they're saying is what his defense brought none of that touched the prostitution thing. And that is what he's being charged with, transporting for prostitution, right? So he's saying that the case laws that were brought about, they're not helping you because they're not talking about specifically prostitution. So let me go back to the chat, see what we're talking about. Because I lose it when I bring it up here. So, right? Did you hear that? Did you hear what he said, right? That he's bringing case laws into this court to fight against prostitution, but none of these case laws are talking about prostitution. One particularly talking about marriage. I know this internet is not running slow. Where's my people? Oh, okay, there we go. So let me see what y'all saying. I hate because I'll be missing it. So while we're doing this, I'm gonna sit this right here. Yeah. Okay, so it says yes, he cannot transport for okay, we said that. Federal law states Trump law. Okay, so thank you for that clarification, right? Because if he's bringing up, so yeah, federal laws are different than state laws. Oh, I need to talk to you personally. Meaning, oh, here we go. Meaning, for example, cannabis is legal in several states, but still legal at the federal. Wait, for example, cannabis is legal in several states, but still legal at the federal level. Illegal, right? That's what I thought you meant, because if you look at it and on a corporate job, right, where there's never been no DOT job, Department of Transportation job will ever, and it's under federal, right? They will never allow for someone to use medical marijuana and be tested and become positive and get to keep their job. Even though marijuana is legal where they work, that's a state thing that was approved. Marijuana was approved. But under the federal law, DOT does not allow medical marijuana use. So that's the difference. And so that federal thing will trump the state in a corporation where we say, yeah, but it's legal. Yeah, but feds say you can't do that and be DOT, right? So that was just an example. So you're right. You're right. Federal does trump state. Hey, Anthony. Hey, Anthony. Thank you so much for being here. We appreciate you being here, where we are a respectful platform and we value everybody's opinion. Again, everybody in the chat, the link is in the chat. Once we're done, you can come on up if you want to talk about it. All right. So I think that's enough of this right here. There's a lot more. We can talk about it another time. He did talk about the First Amendment, as you see right there, which, okay, I got to say this. Holmes argues that because he's an amateur pornographer. Did y'all hear this? I had to read this. Holmes argues that because he's an amateur pornographer and consumer of pornography, his conviction violates the First Amendment rights. That argument fails for two reasons. So let me tell you why the judge took so long. He combed through every bit of their request, and he took the time to answer why he's denying it. So what Puff is saying is that, listen, I'm a pornographer and I consume pornography, but I'm an amateur at this. So you're violating my First Amendment rights. First of all, Combs' conduct is not protected by the First Amendment. First Amendment protection applies only to conduct that is inherently expressive, meaning conduct is inherently expressive if there's both an intent to convey a particularized message and the likelihood was great that the message would be understood by those who viewed it. Don't let that go over your head. You send the message, but it went over people's head. Like they're not taking that message to mean what you're trying to say it means. They have to totally understand the message you're sending, right? They totally understood. Those guys that were transported across state lines for sexual activity, they totally understood what they were going for. They got on the stand and they said they understood. That's what makes it not protected. If combining speech and conduct were enough to create expressive conduct, a regulated party could always transform conduct into speech simply by talking about it. So that's the reason that the First Amendment is not protected. He can't fight the argument of my First Amendment rights are being violated for those two reasons. He only gave two. It's coming back up, y'all. That's what's taking me. That's why it's kind of pausing over here. So, so I like this. I like this, right? Welcome, everybody. Thank y'all for being here. So I like this, right? Says amateur movie director. How? When? Who did you tell this? People that make adult content, everyone knows. Where is this contract? Where is the release of image rights? Oh, wow, that's deep. That's deep, right? So now he's an amateur pornographer that obtains pornography, and they are violating his First Amendment rights. My. It gets more interesting. When I say I want to stop reading it, there's more that comes to light. Bad Bunny said lights, cameras. Right. But don't forget, you're violating his rights, honey. What is the production company? Bad Boy Entertainment. What? Allegedly, these are just jokes. These are just jokes. Just jokes. All right. Thank you guys for being here. Hit the like button. Hit the like button. It supports our channel for free. We're not asking you for any money. We're just asking you for just to hit that like. We're asking you just to share that button, push that share button out to your people. Ask them to come in and join with us in this conversation. We appreciate it so much. Again, I'm putting this out there. If you guys know any attorneys that will come and talk, we've been tapping into some. They've been responding. It's just a matter of locking it in. When we lock some stuff in, y'all, it's gonna be so lit over here. All right, so let me move on. I digress. Let me see if it's anything else, because every time I look at it, I find something else. So he's a pornographer now. What else? What else in this? Combs' incidental filming resembles the fact of Akara versus Cloud Books Inc., in which a bookstore could be shut down to combat the prostitution happening on its premises. Even though that restriction affected the distribution of pornographic materials, the shutdown didn't implicate the First Amendment. The court underscored the fallacy of. So that's what he's saying. He's saying, he gave an example and said that has nothing to do with the First Amendment at all. So your First Amendment rights are not being violated. And they think, and judges said, and I think you may be reading it wrong, because I don't think that's really what's happening here. You're misinterpreting what the First Amendment Act is about, right? It's not involved in what you're arguing. Seeking to use the First Amendment as a clock for obviously unlawful sexual conduct by the defiance device of attributing protected expressive attributes to the conduct. In concurrence, Justice O'Connor emphasized that any other conclusion would lead to the absurd result that any government action that has some conceivable speech inhibiting consequences, such as the arrest of newscasters for a traffic violation, will require analysts under the First Amendment. Against that, Combs relies on 3 state court cases. None moves the needle. None of them moves the needle. First is the Polino case from New York, discussed earlier. Yes, the Polino court worried about the consequences of extending prostitution laws to commercial pornography. Polino, 2005, New York, miscellaneous, Lexus 3430. But Combs didn't engage in anything resembling the adult film distributors that Polino assumed would be shielded by the First Amendment. Let me say that again. Combs didn't engage in anything resembling the adult film distributors that Polino assumed would be shielded by the First Amendment. Recall that Combs doesn't bring a facial challenge, but it's a factual challenge, but instead only challenges the statute as applied to him. He's only challenging how it applies to him. That means that just as Polino confronted a factual situation far from the core of any protected activity, so too does this court. The other 2 are cases where prostitution convictions were invalidated based, at least in part, on free speech considerations. So the People versus Freeman was a California Supreme Court case that held that a California statute on prostitution would violate the First Amendment if applied to a pornographer. So that's where he got that. So now he's a pornographer. And then it says that, but in both cases, the court's free speech concerns arose from the fact that the defendant's purpose was to film a performance, not actual arousal or gratification. So there's where he's making it clear. What case? The case that you brought was for an actual performance, not to satisfy their actual gratifications and what they loved and what they were into sexually in the bedroom. This was actually for a performance where they were actually filming and performing. So that's how it cuts Mr. Combs out. Even if Combs' conduct falls under the First Amendment's protection, his conviction doesn't violate it. So if speech is implicated, then the Mann Act is a content neutral restriction that doesn't, okay, let me start over on that one. He said, even if Combs' conduct falls under the First Amendment's protection, his conviction doesn't violate it. It doesn't violate the First Amendment. If speech is implicated, then the Mann Act is a content neutral restriction that has an incidental effect on speech. Such restrictions are analyzed under the O'Brien test. So the O'Brien test is satisfied. The government has the power to enact the law. It furthers an important and substantial government interest. The interest is unrelated to the suppression of expression, and the restriction is no greater than essential to further the government's interest. So Combs challenges only the second prong, whether the law furthers an important or substantial government interest. And at that outset, the government has a strong interest in controlling prostitution within the jurisdiction. This is only 16 pages. And it's good conversation. Let me see what y'all are saying in the chat. Welcome everybody to the chat tonight. Happy Tuesday, something to talk about. This is great content. Thank you again, Harlem, for being the backbone of this show. We appreciate it. We appreciate it. So what are you guys saying in the comments? Come on, because I can't see them yet. All right. So Alberta said Chuck Berry went to jail for transporting 2 women across state lines years ago. Lies are lies. If taking this angle, he needs to prove Bad Boy Entertainment is a movie production company, not just some sort of party that satisfies his needs, right? So basically, what you're saying, right? I love you guys' comments. Thank y'all for being interactive. But what you're saying here is that if he could set up, if he would have set up or knew to set up Bad Boy as an entertainment, as a movie production company, and maybe a music company, right? That at some point in this whole debacle, he could have brought that out, and that would have been violating his First Amendment rights, because it was set up as a movie production. Because that's my understanding, because that's what he's saying about the one that was violating the First Amendment, because he was doing it for performances, not for actual gratification, just to satisfy his needs. So I think I'm on the right track. I love it when I can kind of comprehend. Anybody else come in that I haven't spoken to? Hello, hello, hello. Thank y'all for being here. Years under the Mann Act. Alberta, yes, under the Mann Act. Okay, got it. So she's responding to you, Bert. All right, so let's move on. We're just about through this document. I thought it was really extra super long. It's just 16 pages and we're on 13. All right, so let's go down here. There was, all right. So on the second, let me read that before I move on. Finally, though Combs doesn't mention the fourth prong of O'Brien, the court notes that the Mann Act isn't broader than necessary. The requirement of narrow tailoring is satisfied so long as the regulation promotes a substantial government interest that would be achievable less effectively absent the regulations, actively absent the regulations. And this means chosen are not substantially broader than necessary to. I don't understand that. The first requirement is plainly met here, as the law works to curb the X trade. And the second is also met because the law applies specifically to interstate transport, not more broadly to X for hire itself. Combs is right that the Mann Act, so he says, Combs is right that the Mann Act's text and applications have changed over the last century, but that has little relevance to his conduct, which sits at the heartland of the Act's legitimate prescriptions. So he's saying, unsurprisingly, then his conviction raises no constitutional problem. So he's saying, yeah, Mr. Combs, you're right that the Mann Act and the text around it has changed. Absolutely, it has changed, but that has no relevance to what the heart of the situation is here for you. So yeah, you're right about that, but it doesn't have relevance to what you're arguing here. It doesn't apply. And then it says there was sufficient evidence to convict under the definition adopted. So what does that mean? Combs's fact-based challenge also fails. Here's why. He argues that the evidence wasn't sufficient to convict him under the definition of prostitution used at trial. So he argues that the evidence was not sufficient to convict him under the definition of prostitution that was used at the trial. So to sustain a conviction under the Mann Act, one of the dominant purposes of the transportation must be for the transported individual to engage in prostitution. That is clearly stated, and that is clearly what they were saying on the stand. There was clearly what they were, that this whole conviction was around, is him transporting prostitutions. He was paying men to cross state lines to be prostitutes. And so that's what he's saying. And he says that United States versus Miller was that interpreting the same language. It says it need not have been his only purpose or motivation, but it must have been more than merely incidental. Combs's argument all sound in the same tenor, that even if paid escorts and they had X with Ventura or Jane, he didn't intend to pay for X at the time of interstate travel. That's not true, right? He tells them that you'll get paid this amount. Are you free tonight? You come do what you need to do for actual activity and you're going to be paid. So that just wasn't true. Instead, he meant to pay only for their time. So he's saying he didn't pay them for that. He was just paying them for their time. If they ended up having X on that time, and even if that was foreseeable, it wasn't the objective of the transaction. So here's how I take that. And I hope y'all are with me. I hope I'm not going over your head or anything. I'm trying to make it clear. But what this is saying is that Combs is now coming back saying, Mr. Combs is now coming back saying, all we wanted is time. We wanted to spend some time. But during that time, whatever happened, happened. I'm not paying for whatever happened other than us getting your time. I'm not paying for that. I'm paying for us having time with you, spending time with you. And whatever happens while we're spending time with you, don't have nothing to do with me, is what he's saying. But I just don't feel like that's correct. I feel like everybody knew that my time was because I was going to make something happen, only if I could make myself erect and make it happen. And even sometimes when I couldn't, I still got paid for it because that was the whole purpose of me being there. And sometimes I didn't get as much. Are y'all with me? Like, does that make sense? Put a 1 if it makes sense. Put a 2 if you like Marvin, not like you're not explaining it right. You don't know what you're talking about. Because I want to make sure, because they stand that basically his argument, again, I'm telling you, I'm only paying for his time. I'm not paying for him to come and have actual acts. And so he's trying to make that make sense for the violation and why he should not be charged for that. And then he says, let me go back up here to some of these comments. Bird, is that you? Yes. Berta says that lies did he tell, and the lawyers, 7 lawyers. Also, actual adult entertainment companies, all actors know they are to sign a contract like likeness release prior to doing anything. Non-adult movie companies do the same thing. Harlem says, Harlem 135, is that what it says? Harlem 135, New York City says, his problem is the law is very specific. That transport aspect is kind of tricky though. Exactly. And so what the judge has done is he written it out in black and white. That I hear what you're saying, but what you're trying to tell me is something so different that doesn't even make sense for why you're even arguing that point, because it's not relevant to your situation. We needed things. Judge was like, I needed you to send me things that specifically talked about prostitution, that specifically talked about the things that mattered in your case that you could fight against, that clearly states one way or the other. Bad Bunny says the one escort was impotent, so that one shouldn't count. That's funny. Okay. So you're getting it 1. Good. I love the ones. Thank y'all. Thank y'all for putting the ones, because I just want to make sure that I'm not like tripping, that you guys clearly understand. And then thank you for participating in that. And so Wright says he's trying to get over it. The prosecution and the judge aren't going to believe that one bit. So here's why, again, Wright, I agree with you. He has submitted, and we just read this tonight, right? And we can clearly see, and I'm not no legal attorney and legal brain, none, but I know I can read and try to and comprehend, and I know that 1 + 1 = 2. I know that's a fact. You can't take that away. I know that. And what he's trying to do is exactly that. But what I said, and I have always said, is Judge Subramanian is by the law, and he's going to comb through that with a fine-tooth comb, and he's going to make sure that what he's responding is by the law. I think he's a stickler to what the law says. I remember in one of our lives that somebody said, like, the state judges, they can kind of maneuver and kind of make their decisions, like even if it was supposed to get 5 years, I'm gonna only give you 1 year because this kind of let people off or either be harder on people. Whereas the federal judges are a little different, that they abide by the rules of the law. And particularly this judge has done that all the way through, is what I saw. And so when Mr. Combs and his teams try to come at him at an angle that makes it look real or look like that's what was happening, like you're a pornographer and you should be like your First Amendment rights are wrong because you are a connoisseur of pornography, right? Well, he says, okay, yeah, but right, you can't prove that. That's not relevant to your situation. And then also all of the case laws that they sent in the case laws, but none of the case laws, according to Judge Submaranian, according to this judge, I can never say his name. He's saying every case law that you send in has nothing to do with prostitution, and you're convicted for prostitution. So what you should have sent me when I asked for you to go back and give this to me is you should have sent me what was relevant to prostitution. You didn't do that. So a lot of these submissions, as you read it in black and white, was kind of trying to get over on him, but he's too brilliant and he's going by the book. All right. All right, we got 2 more pages to comb through really quick. Let me get that off of here so I can see. All right, so moving right on, because we still got some letters to read because that's going to be interesting too. So yeah, let me move to the next page. All right, so Combs's other arguments fall flat. Wow, like he is on him. Dang, this jacked up. Combs's other arguments fall flat. Yes, much of this evidence comes from after the escorts traveled, but it's still relevant and probative. Oh, it's still relevant and probative of Combs's intent beforehand. He says subsequent acts are frequently probative as to intent. And to be sure, some of the escorts may have had mixed motives, as Combs points out, but the evidence still supported that Combs intended to pay the escorts for X and that the escorts indeed had X and got paid. So basically what he's saying, maybe they did have some mixed motives, some mixed conversations, some mixed understandings, but what wasn't misunderstood is the fact that you're going to get paid to come and engage in actual behaviors. So that was clear. And he said, finally, even if the government relied on some circumstantial evidence, it also presented direct evidence in the form of Ventura's and Jane's testimonies. And in any event, jury's verdict may be based entirely on circumstantial evidence. There was also sufficient evidence admitted at trial of interstate transport, of escorts, of Ventura, and of Jane for paid X. For this reason, Combs's arguments that the escorts who testified at trial didn't themselves travel between states isn't grounds for granting relief. So it doesn't matter, because when you have a testimony from Ventura and Jane, it still doesn't matter that at trial they didn't themselves travel between states isn't grounds for granting relief. So through this entire thing, everything that he argued, the judge came back with the law, with what the law states and what the case law shows and what the case laws prove. So now at the end of this, it says no new trial is warranted under Rule 33. So I'll just go ahead and read all of this really quick. Combs says that he should get a new trial under Rule 33 because his RICO and X trafficking counts shouldn't have been joined together with the Mann Act counts. The evidence introduced to prove the former, he says, spilled over and prejudiced the jury against him on the latter. Basically, what he's saying is that basically this case should have never really came about, but that he's saying that they're running it all together. He said these challenges are difficult to prevail on. As a general matter, a Rule 33 motion should be granted only with great caution and in the most extraordinary circumstances. And on top of that, a defendant arguing prejudicial spillover bears an extremely heavy burden. A court considers, one, whether the evidence that related to the dismissed charges was of a type that would incite or arouse the jury into convicting the defendant. And number two, the similarities and differences between the evidence relating to the dismissed charges and the evidence relating to the remaining charges. And number three, the strength of the government's case on the remaining counts. The government argues that these factors shouldn't come into play and that Combs's argument should be summarily something should be rejected. How about that? Because there's no precedence for a new trial based on retroactive misjoinder following a split jury verdict. Putting aside whether that's correct, Combs disagrees. It's certainly correct that Combs is asking the court to find retroactive misjoinder in an unusual circumstances. He says that the evidence that was introduced on the RICO and ex-trafficking charges prejudiced him on the Mann Act counts. So he's saying because because they found him not guilty on the RICO, they had to Diddy saying they couldn't get him on the RICO, so they was gonna get me on something, so they got me on the Mann Act. Mann Act counts, but he was acquitted on the RICO and ex-trafficking. Well, wait a minute. He was acquitted on the RICO and ex-trafficking counts. So his claim is that the jury was prejudiced against him because of the evidence of the racketeering and the ex-trafficking, but still didn't find him guilty of those same counts. As Combs concedes, the Second Circuit has never found spillover prejudice when the jury acquitted the defendant on the allegedly prejudiced charges. That's for good reason. The absence of such spillover is most readily inferable with the jury, where the jury has convicted a defendant on some counts, but not on some counts, but not on others. When the jury was able to distinguish between counts or between defendant and to assess separately the evidence pertinent to each, there's no basis for concluding that a new trial is warranted. As a result, the typical articulation of retroactive misjoinder is that it kicks in only after the latter developments, such as a distinct count dismissal of some counts of lack of evidence or an appellate court reversal of less than all convictions render the joinder improper. Neither of these scenarios ponders a split verdict. So nevertheless, the court declines to reject Combs's argument without reaching the test. Applying the relevant factors, Combs fails to carry his heavy burden of showing the spillover prejudice. The court takes the factors in reverse order, starting with the third, the strength of the government's case. As described earlier, the government at trial presented overwhelming evidence of Combs's guilt under the Mann Act on many occasions with respect to both Ventura and Jane. That evidence consisted of testimony from Ventura and Jane, testimony from the escorts involved, and evidence from text messages and emails. The government proved its case many times over that by itself might be enough to depose of Combs's challenge. But the other factors don't do much to help Combs either. He concedes that under the second factor, if inflammatory evidence would have been admissible anyway on a separate trial for the remaining counts, then his claim of spillover prejudice likely fails. That narrows any factual challenges to evidence unrelated to the Mann Act charges, like arson or forced labor, to give a few examples. But on the first factor, it isn't at all clear that the evidence worked to incite the jury or prejudice Combs. It weighs heavily that the jury declined to convict him on any of the counts related to the conduct. Had the prejudice indeed been so great, one would expect a jury to convict on the most relevant counts before it could spill over and infect the others. A new trial is not warranted. For these reasons, Combs' motion under Rule 29 and 33 is denied. The clerk of court is directed to terminate DKT 485. So ordered. Bam. And that's it. So there you have it. It just ain't, because it ain't. And he gave great reasons. I mean, he responded decently. All right. So what do you guys think? Uh-oh. That was the wrong thing. Okay. So there you have it. ABC. Hey, girl. Hey. He gave his reasons. It is what it is. You can't change it. On the 3rd, on the 3rd, which is Friday, we'll figure y'all. Don't worry about this, okay? Just don't worry about that. I'm gonna get rid of this real soon. But anyway, I digress. But for real, on Friday, we will learn his fate as far as sentencing. He has failed. His attorneys have failed to be able to convince the judge that he should that his charges should be overturned, that he deserves a another trial, a retrial. And so it remains to be seen. We will find out Friday what's going to happen. Now, again, at 10 a.m. Eastern time, so it'll be 9 Central and 8 a.m. Pacific time on Friday. We will be on point. We will know when everybody else know, because we are going to be up in there somehow, some way. So, but we still want to talk about really quick the letters that was written for the prosecution to stand by, I think, to stand by their to stand by the prosecution's request to give him 11 years. They want to see this man do 11 years. Now, I would say, and so we have enough here in the chat. If you think that 11 years is doing too much for the charges that he have, and that they're really just kind of somehow intertwining that RICO into this sentencing request for 11 years, put a 1. Put a 2 if you think 11 years is fair. He probably should have got more. He's guilty, guilty, guilty. Put a 2. These are just opinions. If you don't want to do it, that's fine. But it's just opinion. Just be interested to see how the chat is split or not, one way or the other. I have a 1, I have a 2, I have a 1. So again, the 1 was that 11 is doing too much. And they kind of intertwine that with the RICO, and it's giving him too much time, or asking for him to give him too much time. The 2 is that it's fair. He should get the 11 years or more, What do you think? I have a few ones that are saying that 11 years is too much for what he's charged for, what he's been found guilty for. And I have 1, 2 in the chat that says he should get that 11 plus more. Anybody else? So we got more people in the chat, y'all. Come on, let us know what you're thinking. If you want me to say it again, a 1 says 11 years is too much for what he's been found guilty for. The 2 says no, 11 is cool, and he probably should get more years. So it's a 1 or 2 in the chat. While I'm gonna work to pull up the letters, because in these letters, when you hear them, if you haven't already, they are so convincing, and it's their truth. And I feel like this is where prosecution wins with these letters and with what they're presenting. Now, do I think Judge Subramanian is going to give him 11 years? I don't know. He's too unpredictable. I don't know. I couldn't even call it. I wouldn't even try. I don't know. We will see, because he's just too hard to call. So Wright says the projection is for less time. So the projection is for less time is for nonviolent offenders. That is very clear. Yeah. So again, a 1 or 2, y'all. Thank y'all for participating. So let me go ahead and get a couple of these letters up. I think it's only just a few people that wrote a letter, but I mean, it'll take you back. I've read them. It'll take you back to trial. It'll take you back to where they have to relive the pain that's their truth that they lived. We weren't there. They were there. They said what they said. They felt what they felt. They endured what they endured. And so they're now speaking on saying, hey, will we ever get to feel safe again? So let me get them up and let me let you guys hear their words. While I take a minute to do that, thank you guys again for being here tonight. Like, it means everything. And it just really means a lot for you guys to participate in the chat. And so I appreciate that as well. The link is down there. If you guys want to come up on the panel. Where are you at, Harlem? I wanted to post your. I can't find it. Anyway, don't forget to hit the like button. Don't forget to subscribe to this channel if you haven't already. And I am now pulling it up. So let me see. Let's go back. All right, let's start with Cassie's letter, of course. Download it. We definitely knew that, but we see that we didn't get an impact letter from Jane for whatever reasons, and I don't understand that. Why did Jane not write an impact letter? Like, is that weird? Or is she afraid of something? Like, what happened? So Cassie's letter is Exhibit A. And how did I do that? Okay. All right, so let's share Cassie's letter. Oops. I hit the wrong thing. Right there. Oh, wait. Why are we not able to share that? Cassie. I'm going to share it. against her. Sorry, y'all. Taking me a minute. All right. Oh my gosh, what is the problem? Give me a second. Bear with me. Some of them do it and some of them don't. Why are we not doing it? I did it the same way. Let's try it again. File. Oh. Right. Frustrating. Okay, there we go. All right, we got it. All right, so Cassie's letter first, because he's still paying her. Oh, you think he's still paying her? Oh, and so that's why she's not gonna write the impact letter. So I wonder what happens, like when and if he say he gets, let's just say for instance that he gets 11 years, who's going to pay her rent? Like, I wonder what is her plan now, and if she's talked to him since the trial. I agree with these phrases. Judge is no joke. He's not. And we just can't predict what he's going to do. His family is going to have a hard time. I know. If that's the case, if that happens, it's going to be so sad. No matter what, it's just going to be sad. Can he still pay her rent? I don't think. Oh, because he's still paying her rent. All right. So let's look at the letter. Oh, did it go away? So this is Cassie, and this is what Cassie has to say. So she submitted this through the prosecution, and it reads. I guess I might need these. All right. So I specifically wanted to read this. So, dear Judge Subramaniam, I have been in a cycle of thoughts and then overthought. I've been in a cycle of thoughts and then overthought writing this letter to you. If there is one thing I have learned from this experience, is that victims and survivors will never be safe. Although I can hope for justice and accountability, I have come to not trust anything. I hope that your decision considers the truth and the decision considers the truths at hand that the jury failed to see. For 4 days in May, while 9 months pregnant with my son, I testified in front of a packed courtroom about the most traumatic and horrifying chapters in my life. I testified that from age 19, Sean Combs used violence, threats, substances, and control over my career to trap me in over a decade of abuse. He groomed me into performing repeated X acts with hired male ex-workers during multi-day freak-offs, which occurred nearly weekly. I was forced into lingerie and heels, told exactly how to look, and plied with drugs and alcohol so he could control me like a puppet. These events were degrading and disgusting, leaving me with the infections, illnesses, and days of physical and emotional exhaustion before he demanded it all again. X-Acts became my full-time job, used as the only way to stay in his good graces. I testified that I learned to read Sean Combs' signals, knowing that when he spoke of freak-offs, he was demanding them, and that refusing meant punishment, losing my car, my phone, or worse. He controlled every part of my livelihood and threatened to destroy my reputation by leaking X tapes and a threat he repeated often. His power over me eroded my independence and sense of self until I felt like no choice but to submit. When he believed I had wronged him or was not sufficiently responsive, he also threatened people around me and those close to me, including my family. I regularly worried that displeasing him meant putting my family and friends' safety at risk. I testified how beyond these threats, Sean Combs frequently used violence to get his way. Over the nearly 11 years we were together, Sean Combs would hit me, punch me, stomp on my face, pull my hair, and throw my body in the ground and against the walls. The jury saw pictures of bruises on my back from Combs kicking me and saw the deep gash over my eye caused when he slammed me into a bed frame. The entire courtroom watched actual footage of Combs kicking and beating me as I tried to run away from a freak-off in 2016. People watched this footage dozens of times, seeing my body thrown to the ground, my hands over my head, curled into a fetal position to shield me from the worst blows. This physical violence caused bruises that makeup artists paid for by Sean would cover up, as well as permanent scars all over my body. During my time with Combs, I was in a constant state of hypervigilance, as I always was anticipating demands for X acts or otherwise fearing retribution for any perceived slight. My descent into substance abuse was directly correlated with his increased control over my body, my money, my freedom, and my free will. I used those drugs to push through the horrifying sex acts he demanded, and to numb myself to the physical pain and emotional turmoil I was constantly in. While the defense attorneys at trial suggested that my time with Combs was akin to a great modern love story, nothing could be further from the truth. Nothing about this story is great, modern, or loving. This was a horrific decade of my life stained by abuse, violence, forced X, and degradation. Yeah. I spent the last 7 years of my life slowly rebuilding myself, physically getting clean from the drug abuse Sean Combs forced and encouraged, and mentally understanding how to live with a seemingly insurmountable level of trauma. The horrors I endured drove me to have thoughts of suicide, ones I almost followed through on. If not for my family's intervention and urging that I seek professional care, I have been to rehab, and I have taken part in dozens of types of therapy modalities to comfort, compartmentalize, and cope with the horrific memories of sexual and emotional abuse I endured for nearly 10 years. While what he did to me is always present, I am slowly learning how to live my life free of the fear of horrors I endured. And in doing so, I am fully devoted to my husband and my children. I still have nightmares and flashbacks on a regular, everyday basis and continue to require psychological care to cope with my past. My worry is that Sean Combs or his associates will come after me and my family is my reality. I have, in fact, moved my family out of the New York area and am keeping it as private and quiet as I possibly can because I am so scared that if he walks free, his first action will be swift retribution towards me and others who spoke up about his abuse at trial. As much progress as I have made in my recovery from his abuse, I remain very much afraid of what he is capable of and the malice he undoubtedly harbors towards me for having the bravery to tell the truth. His defense attorneys claims he is a changed man and he wants to mentor abusers. I know firsthand what real mentorship means, and this disgusts me. He is not being truthful. I know that who he was to me. I know that who he was to me, the manipulator, the aggressor, the abuser, the trafficker, is who he is as a human. He has no interest in changing or becoming better. He will always be the same cruel, power hungry, manipulative man that he is. When I come out, when I came out with my allegations in my civil case, he flatly denied them again and again. It was only after the actual video footage corroborated the exact words in my civil complaint that he issued an insincere apology on the internet. Thanks to the footage and my testimony, that is also something he will forever be associated with. For over a decade, Sean Combs made me feel powerless and unimportant, but my experience was real, horrific, and deserved to be considered. While the jury did not seem to understand or believe that I engaged in freak offs because of the force and coercion the defendant used against me, I know that it is true. It is the truth. And his silence should reflect the reality of the evidence of my lived experience as a victim. Reliving in detail the events and truths described throughout the trial and this letter causes me tremendous emotional pain. I'm trying with all that I am to move on. I hope that your sentencing decision reflects the strength it took for victims of Sean Combs. Oh, let's get ready. Oh, yeah. I'm sorry, y'all. Victims of Sean Combs to come forward. I hope that your decision considers the many lives that Sean Combs has upended with his abuse and control. I thank you for your time and attention, Cassie Ventura Fine. So here's what I hear people saying after reading this letter. And this is just what people are saying, okay? That while her situation was traumatic, while we did see the footage of her being traumatized, beaten like no one's business, they're saying that's not what he's on trial for. That's what they're saying. He's not on trial for this. He's not on trial for violence and abuse. He's on trial for prostitution. So do y'all feel like he's being, while they're saying that he's not being charged with that he really in fact is being charged with that? Because that's what her whole letter was about. It wasn't about some of it was, about the prostitution or whatever, but is that what it's really about? Let me go back up here to the comments. I know I can't see now. It's not going to be a nice picture of the court. Let me put it up here. It's not going to be a nice picture at the court with all the media, YouTubers, TikTokers are going to be all in their faces and sad. It's the truth about his kids and his family. Her letter has nothing to do with transportation. Exactly, Bad Bunny. Her letter has nothing to do with the transportation charge. She set up the escort arrangements, hands not clean. Everybody is going to channel it on Friday Live Action. Diddy, I might go down to Manhattan myself. I might go down to Manhattan myself on the New York train. Nope. Great job, Phases. Thank you, Bert. Don't trust me, Alberta. Don't trust me. It will be crazy. Trust me. Verdict day was, yeah. And she put a 2 in there. She's saying that he should get what he's getting. Okay, so that's Kathy. So I was just wondering, like, yeah, like 2 they gave the R 30 years. You're right. Yep. So yeah, I was just wondering if you guys caught that a lot of hers is about the abuse she endured, and she has the right to speak about that. But unfortunately, he's not on trial for abuse at all. He's just on trial for the Mann Act under the prostitution. And so that's what her letter was about. But I wanted to make sure that we did get that out. Let's go on to the next one. Oh, I hit the wrong button. So I definitely want to hear from the remove it. Okay. And let's go to the next one. After the letters, y'all will go. And if anybody has to go, I understand. Just make sure you read the replay. You review the replay. But we're going to read these letters tonight. All right. The next one is Cassie's partner. No, Cassie's parents. So we got 1, 2, 3, 4, 5 more letters to go, y'all. And I'll swear I'll let you go. But we got Cassie's parents. We have Mia. We have Capricorn, Deontay, and we have the chef. And I wish this chef would have made it to trial to get on stand. But after they dwindled people out, she was one that did not make it to the stand. So I do want to hear her. Matter of fact, we'll hear her letter next. Let's just hear hers now. So this letter is from the chef. All right. And we're going to bow. Okay. All right, so the chef is up next. Oh, is it long? Oh, shoot. I didn't read her letter because I didn't even realize. She's speaking, it's nothing like a woman scorned Diddy. She's speaking to a pattern of behavior and character and fearful of retribution. The chef letter is long. So I'm just gonna skip through it then. I mean, we'll look at some of it, okay? So we don't have to add, we don't have to read it all. Let's just see what the highlight of it is, if that's okay. I think it's like 3 or 4 pages. Goodness, that's long. So this is the chef, Jordan, I believe her name is. Yep. Ooh, it is. It's 2 pages long. Ooh, okay. My name is Jordan, and I was Sean Combs' personal chef from the summer of 2007 to the spring of 2010, which is 3 years. During my time, I can say that I was extremely overworked, underpaid, mentally abused, exploited, and at one point I was assaulted by Sean Combs. Not only was I exploited by Sean, I was also exploited by his HR executive staff. Throughout my time there, they would constantly manipulate me into silence and staying in my position by saying they would get help to ensure I had off days. There was also time in which they told me to spearhead the creation of Ciroc flavors. I was one of those. I was the one who chose, sampled, and tweaked the flavors throughout their inception, for which I was never compensated for. So basically, for the Ciroc flavors, she's the one that tasted it. She's the one that tweaked it the entire time, and they gave her nothing for it. She was not compensated. This was the most toxic and abusive workplace environment I have ever been in my entire career. It has been extremely traumatizing to me to relive all of this. It was hard to live through the first time around in my mind, in my mid-20s. Now I'm in my mid-40s. A lot of things I was too young and naive to understand. But the reality of it all is cemented in my mind. I have spent the past year and a half in a constant fight state or a fight mode, and am currently trying to heal and repair all of the damage. There was also a time in which Sean Combs threatened my life to keep me silent about his abuse towards Cassandra Ventura Fine. I have a journal from the time that I never read. From that time, I have journal from this time that I never read until Cassie's case came out in November of 2023. And it was like opening a Pandora's box, reading what my 20-year-old self endured. I was there to witness the start of Sean Combs and Cassie's relationship. This has been an extremely traumatizing time in my life. The past year and a half, having to unearth the past and relive it all again. I never forgot what I experienced during my time there, but I was for sure buried it in order to survive. I've spent the past 18 years building my career in the high profile sector, and this case has destroyed the life I worked so hard to create. When you become personal staff to high profile people, you become part of a secret society. Discretion is the foundation. I don't willingly participate in this case. I didn't willingly participate in this case. What I recognize now, this is what happens with collective silence. My silence gave Sean Combs the space and time to grow into a more violent criminal. When I started working with Sean, he and Cassandra were in the grooming phase. That is what it was in my eyes. She was 19 and he was 36. There were lavish dinners, shopping sprees, etc. All in the guise of creating a new artist. Sean was working her down like men with money do. I was there in Miami when their working relationship turned romantic. During that weekend, I saw Cassandra provide copious amounts of drugs. Ooh, I saw her provided copious amount of drugs. I encountered her extremely high out of her mind, and I offered her food to help bring her down. I witnessed Sean cursing his assistant, David James, out for not having condoms on the yacht. I remember thinking it was crazy and gross. Like, why is he so mad about condoms not being on the yacht? It's never that serious. It stuck out in my mind because that's when I knew this was no longer a working relationship. They were both extremely high the whole weekend and really thereafter. I saw Sean abuse prescription meds, weed, ecstasy throughout those early months. It was heavy drug use. I saw him be extremely controlling, and I would say there was an obsessive nature about him. He would go on drug binges and he wouldn't let any of us sleep, let alone get any breaks. I was working 17 to 21 hours a day, 7 days a week. I worked for almost 2.5, 3 months straight until I had my first day off, my first off day. He screamed and cursed at me when he saw me having casual conversations with Cassie. He said that I wasn't supposed to be talking to her if it wasn't about food. He also cursed me out when he saw me speaking to guests at one of his parties. He was watching me from across the room. Then he pulled me aside and said that I wasn't supposed to be talking to his friends, that he didn't work all these years for me to come and steal his relationships. Sean would cuss me out if I had fed people without his permission. He made me feel like I had to look at the floor and not make eye contact with guests. I'd say like a pimp does to his women. During this time in November 2007, while at the Miami estate, I witnessed Sean Combs get aggressive and broad and borderline violent with the estate manager, Amanda. He was enraged by the fact that Amanda was allowing her house staff to eat. When when Sean Combs questioned her about it, she lied and said she never told me to feed them. Amanda and I actually got into a disagreement about me feeding the staff because I told her I wasn't being paid to do that. I actually called HR to get clarity. They informed me that I was supposed to feed them. One day, Sean observed the groundskeeper making themselves a plate, even though I said they shouldn't because he hadn't even eaten yet himself. Of course, as they are making the plate, he comes downstairs. Once he sees this, he immediately starts screaming and cursing about who told them they could eat. I stood there silent. I didn't want to get anyone in trouble, and I couldn't tell he was furious. I could tell he was furious. Ultimately, Sean's security told him that Amanda told me that I was supposed to feed them. Sean then called both Amanda and I into the kitchen. He started screaming and cursing at Amanda, saying, "Why is she lying? Is she telling me to feed the staff?" Ultimately, as he is screaming, he gets up and he throws a water bottle across the room, saying, "I'm in this MF and King. I'm the MF and King, and you you are lying to my effing face right now." Amanda was saying she told me to Amanda was saying she told me only to provide leftovers to her staff. I told her just tell him the truth. Once he threw that water bottle, I got up and called Dia in HR. I used a phone where he couldn't see me. I asked Dia what I should do because I thought he might hit Amanda. I was instructed to get security to separate them, which I did, all while leaving the phone down on a ledge so Dia could hear everything. Amanda resigned not long after that incident. I believe it fractured their working relationship. Amanda and I never recovered. She blamed me for the incident. Soon after her trip, soon after this trip, my hair started falling out and I was having anxiety attacks with heart palpitations. I asked HR if they could rush my benefits through because I needed to see a doctor. I was diagnosed with stress and induced alopecia and extreme anxiety attacks. I was prescribed Zoloft. Throughout the time, I was constantly calling the office, asking for help and begging for off days. When you work 17 to 21 hours a day, you never really rest because your body and mind are still racing when you lay down. And by that time, when you lay down, by that time, by that time you have to get up for the next day. HR kept stringing me along, saying they would get me up. So I decided I'd have to. I so saying I lost my place. Saying they would get me help so I could have off days. I was so young and I just wanted to prove I could do it. So I stayed, thinking at some point things would change, but they never did. In April 2006, at the Alpine, New Jersey estate, Sean Combs physically assaulted me. We got into a heated argument and I quit, which enraged him. He kept saying I couldn't effing quit on him. As I was walking out of the house, he was following me, screaming, cursing, and berating me. Once the door was open, Sean Combs used all of his might to push me out the door. It was 3 pages. Oh, it's 7 pages. So anyway, she's telling her whole story that she wanted to tell on the stand, I think. So I'm not going to read that whole thing. If you guys want to read it, it's there. You guys to read it. But I feel like she's telling the story that she wanted to tell on the stand, but didn't get called to the stand. Now it's his fault. She's going bald. Basically, that's what she's saying. The anxiety. So I just feel like, again, that has nothing to do with prostitution. That has everything to do with violence, and they already know that he's violent. So I guess what the prosecution strategy is, this is to show the violence, that show that he's not a safe person to get out, because he's not on trial for violence or for domestic violence. So let's move on because it's getting late not for me, but y'all might be. It's a little late. Do we want to continue to go, or do y'all ready to go? Are y'all ready to go? Because there's a couple more, and if they're long, I don't want to keep y'all long. This is a long live tonight. I knew it would be. Tell me what y'all want to do. I'm okay either way. Keep going. All right. Well, let's keep going. We about done. I'm with it. All right. All right. So now we're gonna hear. So again, Chef, that's fine. I mean, I feel sorry for her. It's okay to hear the story, but I feel like where are you guys talking about the trafficking or the prostitution, whatever? All right, so let's go on to Cassie. This is for Cassie's parents. They wrote a letter. Oh, is it long too? I think it's just 2 pages. Okay, it's 2 pages. So let's go. Oh, it's just 1 page. So here's her parents. Dear Judge, we are writing to you as extremely concerned parents regarding the upcoming sentencing of the defendant referenced above. We have read many online reports that state that months are being suggested for his punishment/sentence, as opposed to the many years that we feel he deserves. 11 years is the length of time this horrific nightmare lasted. During that time, our daughter was beaten repeatedly and exposed to harmful and copious amounts of drugs. She was held like a prisoner, kidnapping by the defendant when her face told the story of a beating. She was coerced to perform sexual acts and strangers/prostitutes for the defendant's own sexual gratification. None of the sexual acts were consensual, as there is no consent in a domestic violence relationship. There was always a threat of violence. Everything she did for and because of the defendant was self-preservation. She was, in actual fact, brutalized by the defendant's power and depravity. Our daughter is dealing with the psychological, emotional, as well as the physical aftermath of the abuse and endured at the hands of this defendant. She will be left to deal with the trauma of his abuse for beyond a 27-month sentence with time served, as suggested by the defense attorney. We believe the charges that the defendant was convicted of are not federal crimes, but they are also severe violations of human self-worth and freedom. Clearly, a vile abuse of power coupled with an immune disregard of human life. To sentence lightly is, in this case, that involved such vicious abuse of our daughter's body, safety, and dignity is to dismiss her very existence. To sentence lightly would also send a dangerous message. A sentence that is handed down in months instead of years sends a message that such repulsive behavior can happen without meaningful consequences. In closing, we, her parents, urge you to deliver a sentence for the appropriate sentence that appropriately reflects the severity of depravity of the abuse, the breach of trust, and the suffering that our daughter experienced. The justice system must be a place where the voice of those who have endured sexual and physical abuse are heard, believed, and honored with appropriate accountability. Thank you for your time and your consideration. So that was their parents. I think nothing was wrong with that letter. I mean, that's how they felt. That's their daughter. They had a right to write that letter. I'm glad that they did. That's them. That's her parents. So let's move on. What's the chat saying? It's not pulled up for me. Right, let's remove that. If she got part 30, yeah, it's always be continued with Diddy. Yeah. Let's get that off. Remove. Let's remove this. All right. And so the next letter is going to be from, let's see what Mia has to say. And then we have 2 more. We'll be done. So this is Mia's letter, or her letter. All right, here is Mia's letter. Oh, hers was long. Oh, Lord, hers was long. We'll kind of do what we did with the chef because this is kind of long. So, Your Honor, I'm writing to you on behalf of my younger self, the little girl who once dreamed without fear, who believed that the world was full of possibility, who had faith in the goodness of people, and who trusted that her hard work, big heart, and integrity could carry her toward a bright and meaningful future. That little girl is gone. She was buried alive by an abuser, trapper in a world of terror, abuse, humiliation, and coercive control. This letter has been excruciating to write rather than to begin working for my abuser in my early 20s after I had moved to New York City with only a mattress on my car and a dream in my heart. I was made to believe it was the opportunity of a lifetime to work for him. I was young and naive. I wanted to make a name for myself. I wanted to change the world for the better through my creativity. My dream was to and performer. In these years, I was hopeful and innocent. Preyed on my innocence and on that innocence. And what I thought was a once in a life opportunity gradually became a never-ending nightmare. I experienced manipulation, humiliation, coercion, and violence. I was groomed, exploited, and broken down. He stripped me of my freedom, my safety, my identity, my instincts, and my autonomy. He altered he alternated rewards and punishment to break down my self-worth and instincts, creating dependency and confusion. He dangled my dream before me like a carrot, promising opportunity, mentorship, and advancement. He controlled every part of my life. I needed this when I could go to my I needed this permission for everything. When I could sleep, when I could eat, when I could use the bathroom, when I could go to my room, and even whether I could buy tampons. He created a life where nothing was mine, and I lived in constant fear because his moods could determine my right to exist. Asking for compensation for my labor, including overtime requests or reimbursement requests for work related experience, would lead to him throwing a tantrum, yelling, and sometimes throwing objects in my direction in an effort to humiliate me. He framed me, he framed my request as stealing and made me ashamed to expect my income at all. Though this financial manipulation, through this financial manipulation, he kept me dependent and trapped. My work for the defendant was not a job. It was a captivity. His coercive control and unpredictable violence left lasting psychological scars, anxiety, hypervigilance, disassociation, self-doubt, and an ongoing struggle to reclaim my autonomy. Years of abuse have have rewired my brain. Even today, I feel trapped in the mental and emotional pattern that he created. I live with chronic and severe PTSD, depression, and crippling anxiety. I suffer from deeply intrusive thoughts, derealization, panic attacks, nightmares, and insomnia. When I can when I can get a few precious hours of sleep, those hours are often filled with nightmare terrors that wake me up in a breathless sweat, screaming and crying. I awake with my heart pounding, gasping as if I'm still trapped. I have struggled to feel safe in any workplace because of my PTSD, which has resulted in a fragmented professional record, a bankruptcy application, and crippling debt. I can't go to many of the public places I once loved. Concerts, festivals, clubs without having a panic attack. I have struggled to set roots in any location and build a community of support for fear that my abuser would find me and ruin my life all over again. I avoid social media. I can't listen to music I once loved. I can't watch many TV shows or movies, all for fear that I might be unexpectedly triggered and have to relive some of the worst moments of my life. So she's talking about all of her trauma too and everything that she went through. I think that we heard that as she was on the stand about that. So basically, they're reiterating to the judge to say, "Hey, we actually did live this life, and it would be actually it would be actually offensive if you gave him time served. It would be actually offensive if you gave him just a couple of months. So we're asking that you abide by the 11 years and sentence him." So that's basically what they're asking. So let's go to the next one really quick. We got two more to go. All right. So the next one we're going to hear from is Capricorn and then Deontay, and we will be done. So if it's really long, we won't do too much. We'll do the same. So let's see what Capricorn talking about. Okay, come back. Deontay is about 5 pages. He ended it with, "Judge, this is not a good man taking a jab at a jab at young man." Okay, we'll go like I'll read like the top of it and then I'll go down to his bottom part as well. So if it's really long, I'll go to the end so we can go. So let me get this one in, and then his will be last, and we can be done. But I had to get through these tonight. I had to get through these because all this is important to what we're going to see on Friday. So Capricorn is next. All right. So Capricorn says, "Dear Judge, I testified in your courtroom in this case in May 2025. As you heard, I worked for Puff from 2004 to 2012. And during that time, I got to know him very well. Since Puff fired me in 2012, he has made me blacklisted from the industry, and I've had to take multiple jobs to garner anything near my worth. Today, I'm a single mother to a nonverbal autistic little boy living in Los Angeles. This ordeal has taken 14 years of my life. My career trajectory halted at 33 years old. What I lived through working for Puff and in particular, the events of December 2011 altered the course of my life and have haunted me for years. I feel that I paid with my life for the events that transpired that fateful day we had to relive in federal court. I never wanted this. For many years, I could not tell my story and lived in fear of Puff and fear of how I would feed my son. About a year and a half ago, Homeland Security, HSI case agents found me and asked me what happened. Those agents changed my life, and I would like to say that the Southern District of New York is the epitome of prestige and professionalism. I was handled with the ultimate care. But testifying publicly in front of Puff and his supporters was one of the hardest moments of my life. Every last word you heard from me was the truth. Yet I felt, and to be honest, still feel like I had to fight to prove that I'm a victim because the purpose of kidnapping me wasn't for X trafficking. What it was for was something more serious, more sinister and grave. Violence and absolute power, unchecked in the ultra rich and famous. It's insane to me that of all the things that people heard, 2 counts of prostitution of men is the only thing that remains on the table. I wanted to speak up, tell the truth, and do the right thing when I was asked to testify. But I'm afraid that women and girls in America feel less protected than ever watching what just happened. The lesson seems to be that we should not speak up, not call law enforcement to help, and not say anything, but instead keep our head down and try to make a way, regardless of what happens to us. I'm afraid this may be the only realistic way to proceed in this modern world. The last ray of light is that you provide justice to us. You have a chance to finally help him know that he cannot just do what he wants to do to people. There are repercussions and consequences. He cannot just destroy other people's lives. Karma will come back in hundredfold ways. I would like Sean Combs to serve additional time in a correctional institution. I truly believe that serving more time will serve Puff's life as time away from his money, drugs, and power is the only punishment he will recognize. I hope Puff has life on the other side of his time to make good on the changes he knows he has to make, to spend time with his family and get a chance to correct the damage he has so recklessly done to so many people who only meant well by him. Thank you, Your Honor, for your time, consideration, and for hearing us finally. God bless. Capricorn Clark. I like that one. I like that. I feel sorry for them, man. Gosh, it's horrible. And then our last one is Deontay. And I think Harlem is saying that it's super long. So I'm just going to hit the high points and get to the end of it so we can see how what she's saying about the other one. So let's get him up and we're done, y'all. We'll be done. Deontay. His glasses on my nose. Oh, wait. No. We don't want that one. There it is. Deontay. Down. There it is. Okay. I should just have them all loaded so I wouldn't have to do all that. But anyway, this is it. The government is shut down. I thought they decided not to shut down. Are you sure, right? This is the last one, y'all. Thank you again so much for being here and hanging in here with me. We almost done. Are you sure, right, on that? Okay, let me get this letter up here so I can go. So I can read. All right. So this is Deontay's, and again, we're just gonna skip through what it is because it is 6 pages, and we just don't have time for it. So I'd like to read, of course, the first page. Dear Judge, thank you for the opportunity to share your thoughts. I write with great respect for the court and the difficult decision it must weigh. Mr. Combs' attempt to secure release before his scheduled sentencing hearing demonstrates a troubling lack of accountability and a continued pattern of manipulation. The charges he was convicted of, including violation of the Mann Act, are not minor. They reflect serious, deeply disturbing conduct involving the coercion and transportation of individuals for illegal sexual activity. The thought that Mr. Combs does not believe he deserves jail time is both disturbing and frightening. It underscores the depth of his lack of accountability and the danger he poses. Someone who refuses to acknowledge the harm they have caused, who believes they are above the law, demonstrates the same pattern of manipulation and abuse that has impacted so many lives. The fact that Mr. Combs believes that because he has harmed people he claimed to love or call friends, he somehow deserves leniency and is outrageous. The sense of entitlement makes his actions even more sickening. Yet, Mr. Combs continues to treat the process as negotiable, as though he is merely managing a legal inconvenience rather than confronting the consequences of federal crimes. His efforts to preempt the court's process showed not only a lack of respect for the justice system, but also a refusal to acknowledge the severity of his actions. At one point, there was public indication that Mr. Combs intended to seek professional or mental health treatment. Whether that ever occurred remains unclear. What is clear, however, is that there has been no visible movement towards accountability rather than allow the legal process to proceed in good faith. He has focused on tactical maneuvers meant to bypass the scrutiny and maintain control, soliciting letters of support, crafting PR statements, and attempting to manipulate public sentiment. His plan to escape accountability has been in motion from the very start. His violence has not been limited to private encounters. From orchestrated freak-offs to assaults on staff and strangers, his behavior has left a long trail of victims, many of whom still live in fear. Some of the worst abuse was inflicted on people he claimed to love. This is not the story of one or two isolated incidents. This is the story of hundreds, possibly thousands of people whose lives have been scarred by the unchecked power and brutality. Mr. Combs must also refrain from comparing his crimes to those of others. His conduct stands on its own and has set a new legal and cultural precedent. This is not about relative wrongdoing. It's about individual accountability for a decades-long pattern of abuse. There are many reasons why Mr. Combs should serve an appropriate sentence. Psychological impact on victims. His release would traumatize survivors, many of whom remain in hiding for their safety. The court has a duty to uphold justice to protect those speaking out. Influence over potential co-conspirators. Release would allow him to coordinate with uncharged associates to retaliate or construct false narratives. No remorse or accountability. To date, he has shown no genuine remorse, only carefully crafted statements issued under legal pressure. This lack of accountability should weigh heavily against any request for release. Public safety concerns. The allegations include violent physical abuse, death threats, and intimidation. His release would endanger survivors and the public at large. Beyond legal concern, I want the court to understand that the very real lived impact of Mr. Combs' abuse. This man harassed everyone around us, including friends and business associates, so relentlessly that people no longer wanted to work with us or even spend time with us. We were ashamed to leave the house. The balcony he hung banner from, a place that once offered peace, became a site of terror. The home he held me in against my will, was my own. The keys and phone he stole were possessions I earned through years of hard work. He robbed me not only of safety, but of dignity. His reach was suffocating. He has caused lasting damage to the lives and careers of nearly everyone in their inner circle, past, present, and likely future. Some compiled willingly, many more felt coerced. He taunted victims through songs that contradicted the truth, creating false narratives that could never safely be challenged because of the fear he instilled. He pursued Cassie through her friends, despite both of us telling him she wanted no contact, and tried to manipulate situations by offering favors if I helped deliver to him. He has only declared to his victim that he does not respect or care about the legal system. If he does not respect the court should not extend him any leniency. I do this not just for myself, but for every mother, father, child, grandmother, grandparent, sister, brother, boyfriend, husband, wife, friend, artist, intern, employee, and assistant who sacrificed for a man who only abused them in return. I have watched people take trains, move across the country, leave their families, and dedicate themselves fully, only to be mistreated, exploited, and silenced. Some of these same people have even left the entertainment industry entirely because of his actions. I said I wasn't going to read it all, but it's good. This issue is not only about violence, but about secrecy. Many of us were abused precisely because Mr. Combs wanted us to hold his secrets to maintain his reputation. This truth is, Mr. Combs never respected those who worked closest with him. He rummaged through our lives while publicly pretending to suffer through hard times. He refuses to take responsibility privately or publicly. This abuse was deliberate. The control was relentless. The damage was lasting. The same ailments Mr. Combs now claims as an excuse are the very ones he had carried with him throughout the years of torturing, conducting business, and abusing those around him. They never stopped him. They never stopped him from being violent, abusive, or intoxicated when left to his own devices. They should not serve as an excuse now. True change cannot exist without acknowledging the harm one has caused. Claiming to have changed while continuing to defend the very behavior that led to incarceration is not accountability. It is avoidance. Mr. Combs repeatedly shifts between denying responsibility, seeking sympathy, and reshaping the narrative to suit his immediate needs. Real transformation is consistent, honest, and uncomfortable. It does not depend on who is watching or what outcome is desired. Until he confronts his actions as wrong and takes full responsibility, any claim of change is hollow. I do not expect him to be in jail forever, but I am praying for a sentence that allows the victims to heal and encourage Mr. Combs to genuinely change. For all these reasons, I respectfully urge the court to deny his request for early release and to deny his 14-month suggestion. He has been fighting the truth for the past year, and the ongoing denial is causing additional harm to the mental well-being of victims. Survivors deserve safety, the public deserves protection, and justice demands accountability. Judge, this is not a good man. Thank you for much of your time, Judge Submarine. Your consideration means a great deal to me and to the victims. Respectfully, Deontay. I liked that letter. I'm sorry that I read it all, but I liked that letter, and I see where he took a shot at Young Miami at the end. Sir, this is not a good man. So that was good. I liked everything that he said, about every aspect of that letter. That's an impactful letter. And so they can appreciate that. So we are at the end of our live. Yes, this could, Marva, trying to read without him. Yes, they said at 12:01 Eastern time. Oh my gosh. I thought that they had come to a conclusion that they was not going to shut down. But anyway, that's another live for tomorrow we can talk about because it's late. I appreciate y'all hanging in here with me. Let me know, even after this live, go to the replay and tell me what y'all are thinking. Deontay's letter was really good. We will see what's going to happen on Friday. Again, thank you. Y'all have a good night. I'm out of here and I'm getting ready to go be nosy about the shutdown because I was told earlier it was not going to be a shutdown. So you guys are saying 12:01. It's about that time right now. Have a good night. Have a good night. Have a good night. Thank you, guys. All right, I'll end now. Just trying to read the comment.